Well, I would like to make, I would like to seek your lordship indulgence in making mention of part 2, item number 14 and 15, my lord. I have taken the consent of the other party. This may be listed after a week. I have my personal difficulties, my lord.
Fifteen also you are there.
Yes, my lord. 14 and 15 are two. One. Same parties, my lord. 14 and 15.
Your name is not shown in item 15.
Yes, I'm in both.
You're for the respondent?
Yes, my lord. Same party, my lord.
Mr. Roland?
No objection, Your Honor.
Okay. As paid for by Mr. L.H. Liantrima, learned senior counsel, appearing for the respondent. And not objected to by the other side. Matter stands adjourned for a week.
Madam. Obliged.
Yes.
Orders, item 9.
May it please your lordship, I'm appearing on behalf of the state respondents in this case. The matter was last listed on the 1st of April 2025, wherein the state had submitted that we are waiting for instructions to file the objection, your lordship. So, your lordship, if we are yet to receive instructions, so if 2 weeks time may be granted, your lordship, in this case.
Instructions for what? To file objections?
Yes, your lordship.
What is this IA about?
For filing additional documents at the stage of appellate stage, Your Lordship.
Where is Mr. Joseph? You are for Mr.
I'm for the private respondent, Your Lordship. Hearing. Actually, in the main RFA, I'm the appellant. And in that appeal, my learned friend has filed AIA for filing additional document.
You are the appellant.
My lord, in the main appeal.
You also want to file objection?
I already filed mine.
You have already filed.
Already filed.
Okay, none appears for the applicant when the matter is called. Mr. Caesar Ramchana, learned counsel appearing for the respondent.
Private respondent, Your Lordship.
Which respondent? Respondent oblique appellant submits that he has already filed objection to the IA. We'll stop. Ms. Lalnan, Louis Learned Government Advocate submits that she may be given some more time. She may be given 2 weeks' time to file objection. Mr.
My
Joseph,
lord, I was on legs in the other side, my lord, sorry.
they want some time.
Certain, my lord.
Then in the beginning, you write Mr. Joseph L. Entle, Learned Counsel appears for the applicant.
Applied, my lord.
List again after 2 weeks.
Obliged.
Mr. Joseph, you have somebody with you? Any juniors?
My lord, I have, but there's some misunderstandings. I was in the other court.
You should try to manage because we have only 2 courtrooms.
Yes, yes, my lord.
Principal seat, there are 17, 18 courtrooms. Everybody has to run here and there.
Yes.
So out here, if you are not available or if you are on legs in some other court, you should request your juniors. If not, you request your colleagues.
Yes.
Otherwise, we might end up passing orders saying that no one appears. Okay.
Well, yes.
Item 10.
Lordship, this is an application for continuation of 130 days delay. In
First
filing
time?
Yes, first time.
What are you challenging? Otherwise, in
We are
the
challenging the order dated 29/2025, passed by the learned judicial magistrate first class, Sampai. The order, judgment and order is on page 9 of the application.
what is the order?
The order is
Conviction.
that,
Conviction or acquittal?
Lordship, actually, this order, what we are challenging right here is that, Lordship, during the course of the investigation, the learned Chief Judicial Magistrate has released some seized money to the respondent hearing number 2. respondent number 2 hearing. And, but however, Lordship, as per this, after the trial concluded, that is on page 28 of the application, Lordship, the order. Para number 48 is what we are actually aggrieved of. Para number 48
What
of
was
the order.
seized?
Money from the petitioner hearing.
Okay, the money was not returned.
Money was not returned.
How much was the money?
73 lakhs.
Okay. Where has it gone?
It's in the custody of the respondent number 2. That is the Mizoram Rural Bank.
Whose money is that?
It was seized from 2 persons. One is there was seized 3 times, 3 occasions. It was the money of the petitioner.
Please write down. Heard Ms. H. Lal Malswamy, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 130 days, 130, in filing the connected criminal revision petition against the judgment and order dated 29/2024, passed by the Judicial Magistrate First Class, Champhai District, in criminal trial number 83 of 2019. Next para, issue notice, returnable by 3 weeks. Ms. Linda L. Fumble, learned public prosecutor, accepts notice on behalf of respondent number 1. Have you received copy? Applicant to take steps for service of notice upon respondent number 2 by registered post with ADD within 3 days. List again after 3 weeks. Respondents may file their objection. In the meantime, if so advised.
Item 11.
Lordship, this is also an continuation of delay for 133 days in filing the connected impugned judgment dated 18/10/2024, passed by the learned Special Court NDPS Act Champhai, Lordship.
What is the order? Conviction?
Conviction in Lordship. 10 years rigorous imprisonment.
Who are the respondents here?
Respondent or state, Lordship.
Art Mr. Johnny L. Tochong, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 133 days delay in filing the connected criminal appeal against the judgment dated 18/10/2024, passed by the Special Court NDPS Act Champhai in criminal complaint number 197 of 2023. Next para, issue notice, returnable by 3 weeks. Ms. Vanne Siami, learned additional PP, accepts notice on behalf of the state. List the matter again after 3 weeks. Objection to the IA may be filed in the meantime, if so advised.
Lordship.
Admission item 1.
May I please, Your Lordship?
Yes.
My Lord, here we receive an instruction to withdraw the present contempt petition, my Lord, from the petitioner, my Lord. Here it seems that the matter is regarding the promotion of the petitioner from stage 5 higher academic grade to stage 6 higher academic grade, from professor to senior professor. And the matter was already considered by the Executive Council of the MZU in the light of the order passed by the Honorable Court.
So you have got the relief.
It's still under process, my Lord. Meaning that will be the monetary benefit.
Sorry?
It will be the monetary benefit. Meaning that the petitioner had already get his he is under pension. So he already retired, and the only benefit will be monetary benefit. The evaluation the recommendation of his promotion will be effective from 19 to 2012.
Okay, whatever the facts may be, you see, question is, you have brought this contempt to the notice of the court,
My lord,
saying that the order of the court has not been complied with.
my lord,
Now, you want to withdraw the contempt.
exactly, my lord.
So the other day, your junior was there. He said, we want to withdraw the contempt petition. I said, why do you want to withdraw? Has it been complied with? Then he said, doesn't know. So once the contempt petition is filed, it is between the court and the alleged contemner.
My lord,
Your role is finished. You are supposed to just listen and see the outcome. Because it is not a case of rehearing the matter. It is basically a case of whether compliance is done or not. You say that it's not complied with. So most of the cases, contempt cases are closed. Why? Because it has been complied with. So today you are saying that they are in the process of compliance.
yes, my lord,
So with that, can we close it then?
yes, my lord.
Not withdraw.
We can,
It's not withdrawal, it will be closed.
my lord, yes, we can be closed also, yeah.
Okay. Mr. Evla Lengliana, learned counsel for the petitioner, submits that the respondent authorities are in the process of complying with the direction passed by this court by judgment in order dated 18/10/2019. And therefore, the petitioner would not like to press the contempt petition. Who is appearing?
I'm for the respondent number 2.
Any instruction?
Not yet. I'm yet to receive any instruction. But so far as the instruction received by the petitioner's counsel is concerned, that is what I have had, verbal instruction.
Mr. Elliot Tianrima, learned senior counsel, appears for respondent number 2 and submits that he has no objection if the petitioner does not like to press the contempt petition. Next para, considering the submission made by the counsel for the petitioner that the order of this court is being complied with, the present contempt petition stands closed. Okay.
Obliged.
Obliged.
Item 2.
Your Lordship, as today is fixed for admission hearing, the leading counsel is to appear, and we have taken initiative to represent it for him virtually. But since leading counsel is from the outstation counsel, and early morning he have informed me that he has some technical difficulties to appear. So he kindly instructed me to pray for further time, Your Lordship.
How much?
Kindly.
How much time?
Listed after 2 weeks.
2 weeks. Any objection?
No objection, my lord.
On the prayer made on behalf of, on the prayer made by the learned counsel for the petitioner, and not objected to by the other side, matter stands adjourned for 2 weeks.
Item 3.
Have you gone through the records? See, can we do one thing? Can we just skip to item 4, 5, 6, 7 and come back to this case?
Yes, my lord.
If you are ready. This will take some time, isn't it?
Item 4.
My lord, I'm appearing virtually, my lord, for item 4. My lord, my video has been disabled, my lord, by the court master.
We can't see you.
My lord, my video has been disabled by the court master.
Who's that person sitting there? Please see.
Yes,
Yes.
yes, yes. Now it has been enabled.
Yes.
Yes, my lord. My lord, there
You
was
are
a
you are
case-
for the You are for the petitioner?
I am for the petitioner, my lord.
Okay. So, why is it listed today?
My lord, it was as per the last, your lordship order, there was a direction for filing of the affidavit in opposition by the income tax department that has not yet been filed. And your lordship had stayed the recovery proceedings.
That is one thing.
Yes, my lord.
The other thing is respondent numbers 2 to 5 has not been served notice.
No, my lord, my learned junior is over there, my lord. He said that he had furnished the copy to the court. And my lord, as per procedure, the court sends it. I mean, I am not so sure about the process, my lord, of the, my lord, the Guwahati High Court, because I am from Calcutta. But my learned junior told me that he has filed the copy of the petition in the court. And as per the practice, the court itself sends it.
That's what.
I don't.
So,
Yes, my lord.
the steps was taken to serve notice to respondent numbers 2 to 5, but there is no acknowledgement till now. Neither AD card has come back nor unserved notice.
Shall I, my lord, take the step to get it served and seek the acknowledgement from 2 to 5, 2 to 4, my lord?
2 to 5, they're not from the station. They are from Shillong, Delhi, Silchar.
So, my lord, if your lordship directs, then I will take the appropriate step to ensure that, my lord, that on the next date of hearing, my lord, it is served.
Yes, Mr. Murmu. You are Thangram Siam.
Yes, Lordship. With this regard, Lordship, as per the court order, notice was sent to the respondent number 2 to 5. Till now, any return is not there.
That is what we are saying. You're repeating again what we are saying. We know that story already. You're repeating the same old story. Now, when did you take steps?
But immediately, as your lordship directs, we will take the step.
No, let me ask your junior, because this court does not hear two persons at a time
Right, my lord, right.
from the same party.
Yes,
When did you take steps?
On 23rd. On 23rd.
23rd March.
Yes. No, 24th March. Lordship.
We'll do one thing. We'll ask them to track the postal consignment and,
Yes, ma'am.
and put up a report. We'll post this matter again after perhaps 2 weeks.
2 weeks, my lord. Which date, my lord? On 19th?
You want a date?
My lord, because I am from outside, my lord, and from 21st to 7th, I will not be, my lord, available. So any date prior or after that, my lord, will be fine.
19 is fine by you?
19th is fine, my lord.
Okay, please write. Your good name, Mr.
I am Vinay Saraf, my lord.
Mr. V.K. Saraf, Learned Counsel appears through VC. While Ms. Caroline K. Lungoipu, Learned Government Advocate, appears for respondent number 6, and Ms. Zarem Sampu, Learned CGC, appears for respondent number 1. Stop. Office note dated 2/5/2025 indicates that neither AD card nor unserved notice has returned back from respondent numbers 2 to 5. Stop. Under the circumstance, registry to track the postal consignment and put up a note. Release the matter again on 19th of May 2025. Interim order passed earlier shall continue till then.
Grateful, sir.
Item 5.
My lord, I seek 3 weeks time for obtaining instruction in this regard. Then
were
the
given-
same has not been objected by the counsel for the petitioner also.
You were given 8 weeks time last time.
Yes.
Now it's come down to 3 weeks. Next time it will be 2 weeks. Are you complying or not? That is
My
the issue.
lord, I have to obtain instruction. As per my latest instruction, I was requested to seek 8 weeks time. My lord,
For what?
for
There has to be a purpose behind. We just adjourn matter like that.
for
eight-
obtaining
8 weeks.
instruction. As per my letter, my lord.
You are appearing for which respondent?
All all the respondents.
All the respondents. Who is for the petitioner?
Balanghaka, he already informed me that he has no objection in this.
So he has declined to come.
Yes, my lord.
This kind of practice is not appreciated. You make an out of court agreement somewhere and only one party appears and you take time like that. Both parties should be here, isn't it? As prayed for by Ms. Zaram Sangpui, learned counsel appearing for the respondents. Further 4 weeks' time is granted to get instructions.
Item 6.
Your Lordship, in this matter, although pleadings are complete, I'm filing one IEA this morning for amendment of the writ petition, my Lord, because we need to incorporate one prayer challenging my termination order issued by the CIDC. At the time of filing of the writ petition, it was not yet issued, and I have mentioned in my writ petition.
What did you challenge then?
I have challenged the termination order direction given on the basis of the order passed by the governor. Then direction was given by the District Council and Minorities Affairs Department.
No,
to the CIDC.
Without the amendment, what did you challenge?
We challenge that direction given by the District Council and Minorities Affairs Department.
Direction given?
Yes, to the
now what do you want to challenge?
Now I have to add that particular termination order by the CIDC. Yes, my Lord.
Just show me which is that impugn order which you challenge in the writ petition.
Yes, Your Lordship.
Page number?
Page number is... My Lord. The impugned, page 55, my Lord.
55.
55. This is the first one.
What is the abstract? This is abstract from the governor.
Governor, my Lord.
So now, based upon this, they have issued an order.
Yes, exactly, my Lord. And the next page is page 56 is the reminder. I have also challenged this one in my
reminder
petition.
also.
Yes. And
you have challenged annexes 7 and 8.
7 and 8, my Lord. And when the CIDC respondents filed their affidavit in opposition, they annexed the termination order. So I need to, only to that extent, my Lord, my amendment will be pertaining to that extent.
Have you annexed a copy of the order dated 6/6/23? Order of the governor?
No, my Lord, since I could not obtain the copy, I have mentioned in my writ petition the reason why I could not obtain.
But you have asked for interim stay of that order, 6/6.
Yes.
There is no order.
Yes, there is no
Copy of the order is not annexed.
Yes, my Lord.
So when are you filing the application?
This morning, my Lord. So it may come up with the IA again, if your Lordship can permit me.
Yes.
No objection, my lord.
Mr. Bilal Ramenga, learned counsel for the petitioner, submits that he has filed an IA this morning for amendment of the writ petition in view of the fact that pursuant to the direction passed by the governor for termination of the service of the petitioner, who has passed? The Chakma Autonomous District Council.
Yes, madam.
Has passed the order of termination. And unless the petitioner challenges this said order, the writ petition would remain incomplete. Stop in view of above. When do you want it?
It may come up along with the IA, my lord. This
When? List the matter.
after. Maybe it will be listed within this week also, my lord. IA.
In view of above, registry to verify and connect the IA to the instant writ petition and list the matter. When?
List the matter with the IA, my lord.
Tomorrow?
Or day after.
After is Wednesday.
Thursday, my lord.
Okay, leave the matter on Thursday. Give the date, please. Thursday will be what? 8th.
Yes.
Okay, next.
Much obliged.
Oblige.
Item 7.
Yes, Mr. Roland. What is
Your
this?
Lordship, service is completed and I have served the notice by way of Dusty, and I've also filed a affidavit, Dusty affidavit on 5/3. Still, I believe no one has appeared till date.
Dusty upon which respondent?
Respondent number 1.
1. How many respondents are there?
There are 5 respondents.
Who is for the government? Ms. Banesiam is there?
Yes, my lord.
4, 2, 3, 4, and 5. What is this matter regarding CRP?
Lordship, this is for to set aside the order dated 16/1/2025 in substituting the instant petitioner.
16-1, which is that? Where's the order?
I'm sorry, madam. 37/2024.
Where's that? Show me.
Page 41.
Page 41. Yes, what is this order about? Why are you aggrieved by this order?
Yes, Your Lordship. The father of the instant petitioner, he was not initially impleaded in the civil suit. So, so he was later on impleaded. Application was filed for impleadment of the father of the petitioner. However, during the pendency of the application, he was expired. The father of the petitioner was expired. However,
No, tell me, who has filed the civil suit?
by the
KM Lianzola.
KM Lianzuara,
Respondent number 1.
Smaller,
Suit for what?
sue for damage.
Damage.
Damage compensation.
Damage compensation.
Yes, my lord.
What kind of damage compensation?
A road was constructed. Actually, the tender was, the father of the petition is a contractor. So a tender contract was issued in the name of the father of the petitioner. And however, the work was actually done by a true power of attorney, work was actually done by a third party. And they say that they claim that they have damaged some of the land of the respondent number 1. However, there were already agreement between the parties. Outside settlement was already made, and some amount of money has also been paid to the respondent number 1. But later on, they have filed some, I don't know, they have filed another suit to claim another compensation for this.
So, respondent number 1 says that his land was damaged.
My lord,
Construction done by a third party.
third party. By using
The contract was in fact issued in favor of the father of
father
the
of the petition.
petitioner. And they have come with some settlement. In spite of the settlement, he filed civil suit.
Yes, my lord.
So the civil suit is pending.
It's pending.
Then why are you aggrieved by this order?
It's a lawsuit. First of all, substitution application for substitution was filed beyond limitation period.
Who filed the substitution?
The
Respondent number one.
one. Yes, my lord.
Where is the substitution application? And what is the period of limitation?
90 days.
90 days for substitution.
Yes, my lord.
90 days from which date? Date of knowledge?
From the date of from the death of the party.
Death.
Death.
You have annexed the civil suit, but where's the IA? CM application, in fact.
CM application. CM application 435, page 30.
30. Did you file any objection to that?
That's what you lost it. The petitioner, the father of the petitioner expired sometime in, he was expired on 18/3/2023. However, after seeing the daily orders, it says that someone was issued to the defendant number 5 in the CMA. So it serves no purpose when the respondent is already expired. It says that after someone was issued to the defendant number 5, no one appears for the defendant number 5, and accordingly he was impleaded.
Who's defendant number 5?
As a father of the petitioner in impleadment, and later on, so he has no chance to have an objection, and in substitution, yes, substitution also, he has not received the summon. It was served to the defendant number 5 again. He's the son of the defendant number 5 in the main suit, but still the substitution also, the summon goes to the previous defendant number 5. The
Who's no
address
more?
of the defendant number 5.
Who's no more?
Who is no more. And also, as per the the pecuniary jurisdiction, it also, the valuation of the suit, it was written as above 5 lakhs. And as per the Mizoram Civil Courts 2000, Civil Courts Act, Section 14, the above 5 lakhs should be handled by the Court of Civil Judge Senior Division.
Where does it say above 5 lakhs? It says amounting to rupees 5 lakhs.
Above, it's written above.
Where?
It's in the main suit.
Page 43. Come to page 43. In the matter of a suit for payment of compensation amounting to rupees 5 lakhs. Where does it say above?
Page 49. Later on, it was the plain was amended. Para number 12. That the instant suit being valued above 5 lakhs.
And what is the pecuniary jurisdiction of a civil court?
Junior
Civil-
division is
civil
below
judge.
5 lakhs.
Below 5 lakhs.
Below 5 lakhs.
So what has happened to the suit? He did not get the chance to contest this suit. Number 5.
My limited prayer is like,
No. Question is,
yes,
suit was filed in 2023.
okay.
That time the defendant number 5 was alive.
Yes, he was alive. He was earlier not impleaded
Earlier not impleaded.
in a civil suit, yeah.
Then when was he impleaded?
He was impleaded
During his lifetime?
during his lifetime.
Did he
I
file
mean,
objection?
application was filed during his lifetime. However, during the pendency of the impleadment, application was pending. He was expired.
Then what order was passed?
He was initially he was
If he
impleaded
expired
anyway,
during the pendency of the impleadment application,
and he
if
was
he ex-
expired anyway.
if he expired, do you mean to say the court impleaded an expired person?
Yes, my lord.
Where? Where's the order?
Yes, my lord.
What is the remedy you're seeking today?
Your lordship, to set aside the order dated 37/2024 for substituting the instant petitioner, since the application was filed beyond the limitation period, and also my ground is like the court of
It will go back to the court again.
yes, your lordship, no problem.
It'll go back, then they'll file an application for delay. Then ultimately, if the delay is condoned, then you can raise the issue regarding the pecuniary jurisdiction also. Because from this court, it'll not be possible to examine all those things, isn't it?
Yes, my lord.
Your specific case before this court is regarding the respondent number 5 being substituted, or I mean the defendant number 5 being substituted by filing an application beyond the period of limitation. Let us see the Limitation Act, which is the article. For substitution.
Order 22, Rule 4.
CPC.
Order 22. Yes, your lordship. CPC.
You have served notice to the respondent number 1 by Dusty.
Dusty. Earlier we have served, but ID card was not written, so we have read for Dusty service.
What is the address? He is from Aizawl or where? Which place?
Well, Samtlang.
Samtlang? Samtlang?
Samtlang.
Okay. Order 22? Rule?
Rule 3. Rule 4, Sub-Rule 3.
It does not give any limitations. We'll have to go by the Limitation Act. Okay, within the period specified in the Limitation Act. So we'll have to go by the Limitation Act only. Rule, Order 22, Rule 5, Rule 4 is regarding the procedure for substitution. Insofar as the limitation is concerned, it is provided by the Limitation Act, I think.
Article 120, Your Lordship.
120.
Yes, ma'am.
Under CPC, to have legal representative of deceased or appellant of a deceased defendant or respondent made a party 90 days. So defendant number 5 died on which date?
18/3. 2023.
2023.
Yes, my lord.
Then application filed on?
Application was June 2023.
Sorry?
June 2023. The month of June.
From where are you seeing that?
Annex of 4 series.
Page?
Page 33.
Page 33.
Yes, my lord. The date is not so clear, but I can see the month.
So he expired in March, April, May, June. If you are saying it's filed beyond the period of limitation, you have to be very specific. Date of death, date of filing. We are concerned with 90 days. It might so happen that it was filed within 90 days. If it was filed in June.
Yes, my lord. I believe I have clearly stated the date of filing.
Where have you stated?
Page number 7. Para 8B.
20 June.
26, 2023.
20th of June.
Yes, my lord.
So just calculate 18/3, 23 and 26, 23. It's about 3 months only.
Yes, my lord.
90 days.
A few days. Just a few days. Limited for a few days.
So you tell me it was delay of how many days? You should have done the math.
Yes, my lord. Sorry, my lord.
Simply saying it was filed beyond limitation will
Yes,
not do.
my lord. It's about 2-3 days. However, the condemnation, there was no prayer for condemnation anyway in the application for substitution. And in a similar case, the same petitioner was also substituted. And after filing an objection, the father of the petitioner was abated. As part of CPC Order 2243, if substitution was not filed within period, the court has to abate the petitioner. I mean whom it was substituted. The deceased person has to be abated. But that was not done in this case. Order 22, Rule 4, Sub-Rule 3.
Main thing is the calculation is missing. You say that is not filed within time. How do we calculate? Let us see the application again, the application for substitution.
It's 30.
Page 30.
Yes, ma'am. And Your Lordship, if I may, if you might take you to Annex 4 series, daily order, issue summons to the defendant number 5 through plaintiff. Page 34 also, plaintiff, issue summons to defendant number 5 through plaintiff. So that means it has been served, someone was served to the defendant number 5 who was already passed away. Yes, my lord. 2023. March 18-3. Lordship, as per my calculation, it's 4 days after the limitation period, after 90 days.
Date of filing you should not count, I think. Date of filing is 20th. Without counting that it's, I think, 3 days.
3 days.
3 days. Government, what do you say? Yeah, your mobile.
Yes, my lord. From the order sheet which have been annexed by the applicant, my lord, it can be seen that on 17 to 2022, based on CMA number 438 2021, the defendant number was impleaded as a parties.
Where is that page?
Page 17.
Order dated?
Order dated 17 to 2022. So here, my lord, Pu F. Kap Sanga was impleaded as a defendant number 5. And during this time, he was also represented by his counsel. And later on, my lord, in page number 20.
Page 20.
Yes, order dated 18/11/2022. Here, my lord, it can be seen again that counsel for the defendant is present and prays time for submission of WS. So they have knowledge. And later on, after this, Mr. F. Kapsanga passed away, unfortunately. Then after he passed, the court decided that he has to be substituted by his legal heir. So at that time also, my lord, they have the knowledge. And in my humble opinion, in my submission is that, my lord, the counsel for the appellant has to approach the trial court. If they have any objection regarding to this, they have to raise before the trial court, my lord.
Okay, but one thing is there, the plaintiff has filed application for substitution.
Yes, my lord.
According to Article 120, such application is to be filed by within 90 days.
Yes, my lord.
But they have filed this application after on the 94th day.
Yes, my lord. Regarding that, they have to submit their objection before the learned trial court.
No, there's no
They have
chance. There's no chance for filing objection. Trial court has simply allowed it.
They keep on summoning defendant number 5, my lord.
Defendant number 5 is not the
The
defendant
thing
number
is
5
that
is
in
not
the
the
order
present
sheet,
the
in the
present
order
petitioner.
sheet, they
Because the-
didn't write that the person who represented, who is substituted, the defendant number 5 is a legal heir. They didn't name him as defendant number 6. They just write defendant number 5 represented by his legal heir, my lord.
Where is
So
that?
it comes like defendant number 5 only, and in this defendant number 5, they mean to say that he is the legal heir, since Mr. F. Kapsanga died already at this time, and it was substituted by his legal heir,
So
his son.
the person who is supposed to substitute the defendant number 5, his name also should have been written in the application.
Yes, my lord.
That was not done. They go by the same name only again, that person who is already, who's no more. And if you come to page 33,
Yes.
it says, bottom of the page, issue summon to defendant number 5 through plaintiff.
Yes, my lord.
So how can a dead person come?
and the deceased, if I may say,
Here,
and
my lord.
the deceased father of the petitioner resides in Twickwell, and the present petitioner, he has established his residence in Dokui. So that means they have served the summon in Twickwell and not in Dokui.
My lord, what I would like to mention here is that at this time, when the defendant number 5 was summoned, at this time the application was still pending, and they are waiting for written objection. He is not substituted yet at this time.
Which time?
Here, my lord, in this order, I cannot read the date exactly, my lord. This is an application under Order 22 of the Court of Civil Procedure 1908,
The
filed by
date
the
is
applicant.
26.
Date is 26.
26.
Yes. And here it is said the submission of the WO by the opposite parties. So the
No.
application is pending at this time.
The application itself was wrong. That is why I'm saying. They should have straight away put the name of the present petitioner and say that you are the new person to be substituted. Because defendant number 5 cannot receive notice. He's no more there. So is this the first time it is coming after the Dusty is complete?
Yes, my lord.
When was Dusty served?
5-3.
Five. Five three. Then you filed this application on 12/3, affidavit on 12/3. And It was already listed earlier also.
Yes, my lord.
On 28th of March, no one had appeared. LCR is available. LCR.
I don't think so.
It is available. This is what the, let us see the LCR. In the cost list, you'll see it's within bracket with LCR. The court directed that issue summon to defendant number 5 through the plaintiff. Now, what did the plaintiff do?
They serve the summon to the to equal the person who has already passed away into equal the address.
No, but where's that acknowledgement by anybody?
Don't have that.
The order sheet does not say anything.
Yes. And
It keeps on saying issue someone, issue someone.
And in fact, the deceased was, even when he was alive, there was no particularly indicated in the order that he was represented by a particular counsel.
He did not have a counsel.
That's what we have seen from the order sheet. He was not represented by anyone. It was not particularly indicated.
Ms. Vanachemi has shown me that some order was passed represented by counsel.
It was written represented by counsel, but who is the counsel and when he was represented, it was not indicated.
So and so is impleaded as point number 5. Fix 23.3 for submission of amended plaint. Then learned counsel for the defendant is present and prays more time for WS. Consider the plain allowed. Have you gone through the lower court records?
Yes, ma'am.
There must be a vakalandama there.
We have not seen anything.
No vakalandama.
We have not seen. There is nowhere in the order indicated the counsels also. And my learned friend is a state counsel, and they are not the rival party in this in the instant case. So they have no. They have no.
No, we know that. You think I don't know that? But she's assisting the court.
Yes, ma'am.
That is more important. See, number 1 is not present, so she's assisting us. And we're looking at the LCR also. LCR is here. It's basically the order sheet. The Xerox copy of the order sheet. And of course, application is here. See, in all these orders passed, there is no particular date. date of order. Below it said memo number. So memo number and that date, is that the date of the order? Is that how the orders are passed in the trial court?
Not normally.
Ms. Vanesiami?
No, my lord. The date.
See, date of judgment, date of order and all that, normally it's either on the top or on the last part.
Yes, my lord.
Passed on this so-and-so date of 2025, like that. But here there's nothing on the top, nothing on the bottom. On the last part, you have memo number so-and-so, dated. So memo number means this is for issuance of the copy of the order to the parties.
Exactly, my lord.
Plaintiff, defendant, case record, all that, copy will go there. So the date of issuance of that order will be the memo number. But the date of the order has to be different. When was it passed?
This order was reflected in the order sheet, my lord, annexed on page number 38, 37, 2024.
The same day.
37.
Correct.
Yes,
Order sheet says 37,
yes,
but that also should be available in the order passed, isn't it?
exactly.
Otherwise, every time we'll have to go to the order sheet and see which date it was passed. I think this order will have to go. But notwithstanding the setting aside, I think they will have liberty to, if they want to file appropriate application, that liberty should be there. We can't deprive them of that opportunity. Please write hard, Mr. Ronald. K. Ronald. K. Roland. Learned counsel for the petitioner, and Ms. Vanesiami, learned government advocate for respondent numbers 2 to 5. None appears for respondent number 1, despite notice. Stop. Next para. By filing this application under section 115, read with section 151 of the Code of Civil Procedure 1908 bracket CPC, the petitioner seeks revision of the order dated 37/2024 passed by the Civil Judge Junior Division Roman 4 Aizol in CMA number 435/2023 arising out of civil suit number 38 of 2019. Stop. The learned counsel submits that the respondent number 1 filed civil suit number 38 of 2019. Where's that civil suit? Page
17. Sorry. Page 42.
against the official respondents number 2 to 5, and also against one Sri F. Kapsanga, claiming compensation of more than 5 lakhs for destruction of his land in connection with the construction of Samtlang to Hualngonghun Road. To stop, initially, Sri F. Kapsanga was not pleaded as a party defendant, and he was later on pleaded as defendant number 5. Stop, during the pendency of the civil suit, the defendant number 5 expired on 18/3/2023. And the respondent number 1, oblique plaintiff, filed, where's that application?
Page 30.
Hmm?
Page 30.
13.
30. 30.
Filed
is 435.
CMA number 435 of 2023 for substitution of defendant number 5 by his legal heir. Stop, the learned counsel submits that the legal heir of the defendant number 5 was nowhere mentioned in the application, and the substitution application was filed beyond the period of limitation. Stop. The learned trial court, however, issued notice to the defendant number 5 who was no longer alive through the plaintiff. Stop. When the defendant number 5 did not respond on various court dates, the learned trial court passed the impugned order impleading the present petitioner as defendant number 5. By substituting the original defendant number 5 on, what is the date? 30, isn't it? On 37, 2023. The learned counsel submits that the petitioner is the son of the original defendant number 5 and does not reside and resides, not does not, and resides in a different locality altogether. And therefore, without there being any notice to the petitioner, the learned trial court could not have impleaded him as defendant number 5 in the civil suit and that too beyond the period of limitation. Stop. The learned counsel submits that Order 22, Rule 4, bracket 3 of the CPC provides that where within the time limited by law, no application is made under subrule 1, bracket 1. Bracket, open bracket, for substitution of the deceased by his legal heir if cause of action survives, close bracket, comma, the suit shall abate as against the deceased defendant. Stop. He therefore submits that since no application was filed for substitution of the original defendant number 5 within the prescribed time, comma, the suit in terms of the said provision would stand abate insofar as the original defendant number 5 is concerned. Stop. However, the learned trial court through the impugn order has illegally impleaded the petitioner as defendant number 5 in the civil suit, and accordingly the impugn order should be set aside. Next para, Ms. Vanesyami, learned government advocate, has drawn the attention of this court to the order dated 17/2/2022 passed by the lower court in the civil suit wherein the original defendant number 5 was impleaded as a party defendant. Stop. She submits that from the said order sheet and the subsequent orders passed, more particularly on 18/11/2022, it appears that the defendant number 5 was represented before the trial court. Stop. She submits that if the defendant number 5 was represented, his counsel could have informed the court about the demise of the defendant number 5 and or object to the civil suit as well as the application for substitution. Stop the same having not been done. The petitioner cannot raise the grievance of the defendant number 5 being substituted by the present petitioner. Next para, I have heard the learned counsels for the parties, and I have perused the materials available on record, including the LCR of the CMA number 435 of 2023. Stop in the order sheet of the main civil suit. Although the learned trial court has recorded that counsel for the defendant is present with a prayer for more time to file WS. But it may be seen that defendant number 1 to 4 are the official defendants, whereas defendant number 5 is a private defendant. So stop. It cannot be made out as to whether the appearance of the defendant recorded would mean the appearance of the official defendants as well as the private defendant through their respective counsel. Stop further. The respondent number 1 oblique plaintiff in his application for substitution that is CMA number 435 of 2023 has not incorporated the name of the present petitioner either in the cause title or in the statements made in the application, including the prayer portion.
Your Lordship, It's included in the prayer portion. The name is.
Okay, cancel the prayer portion then. Either in the cause title or in the statements of the plaint, okay? Of the application, not plaint. Stop. The said application was said to have been received and registered on 26/2023. Stop. The original defendant number 5 expired on 18/3/2023. And therefore, the application for substitution apparently was filed beyond the period of limitation, since Article 120 of the Limitation Act prescribes 90 days time for filing substitution application. Stop. The respondent number 1 / plaintiff did not file a separate application seeking condonation of delay in filing the substitution application. To stop. This aspect of the matter appears to have not been considered by the learned trial court. For reasons best known to it. Stop. Further, although the original defendant number 5 expired on 18/3/2023, but yet summon was issued to him through the plaintiff. Stop. The record also does not reveal as to whether someone was indeed affected to the no, you can cancel that sentence. Next para, the learned counsel for the petitioner has also submitted that the claim for compensation made by the respondent number 1 / plaintiff is above 5 lakhs, and therefore the suit has been filed beyond the pecuniary jurisdiction of the Civil Judge Junior Division. To stop. On this ground as well, the civil suit could not have been entertained by the learned trial court. Stop. However, this aspect of the matter will have to be dealt with. However, this court is not inclined to go into this aspect of the matter at this stage. In view of the fact that the main challenge made in the instant petition is with regard to the application for substitution having been filed beyond the period of limitation and without notice to the petitioner. Next matter, upon due consideration and upon hearing the learned counsels for the parties, this court is of the considered view that the impugn order dated 30/7/2023 is not sustainable, and accordingly the same is set aside. Stop. Notwithstanding the setting aside of the same, the respondent concerned shall not be precluded from filing appropriate application before the competent court as may be permissible in law. No, you write like this, notwithstanding the setting aside of the impugn order, the respondent's concerned would be at liberty to seek remedy as may be available in law. Yes, what can we observe?
I believe, Lordship, if I may submit,
Yes.
the respondent number 5, I believe it's his duty to take appropriate steps. Whatever step is available, it's his duty to take such steps. And we are not.
No, that's why I'm making just an observation that it's not, they're not barred. They may try to file an application, whatever it may be, it's permissible in law, but not in such a manner. To seek appropriate remedy as may be available in law. That much.
Yes.
Okay. So CRP stands disposed of, okay? Okay, I'll rise for 5 minutes and come back.
As per the last court's order, Your Lordship, we had issued notice to respondent number 1 to 5, and the ID card has not yet returned, Your Lordship. As per today's court's,
1 to 5, isn't it?
Yes, Your
Who are
Lordship.
they? 1 to 5.
Your Lordship, one is the Chief Secretary to the Government of Mizoram.
All of them, 1 to 5. No ID card from anyone.
No, Your Lordship.
This, when did he take steps?
We had taken steps on 21st of March, 21/3/2025.
Ms. Vanessiami, what is to be done?
Yes, my lord, I have no instruction regarding to this. Actually, in the contempt case, my lord, we are
I know.
not standing as an advocate,
I know
government
that.
advocate.
I know that, Ms. Vanessiami, but the thing is that, can you inform them that this thing is pending? They should do something about it.
Yes, my lord, I will do that. I will inform them and get instruction.
Please write down. Office note dated 2/5/2025 indicates that neither AD card nor unserved notice has come back from the respondent numbers 1 to 5. Stop under the circumstance. Registry shall track the postal consignment and put up a note by the next date. List the matter again after a week. Meantime, you can have a word from your connection.
Yes.
If not, we'll have to do something about it.
Yes.
Yes.
Item 3.
Yes, what happened to this case? Last time we had taken up this matter, isn't it, for some time? And
Yes, Your Lordship, I have gone through the reports
Hmm.
submitted by the department. And as per this report, my lord,
Hmm.
these marks obtained,
Hmm.
which they have submitted, is their answer sheet, my lord. It's the answer sheet.
Answer sheet.
Yes, and it is a handwritten, as expected by the learned counsel, my lord. My learned friend has mentioned that they had not seen the handwritten,
Hmm.
but these reports are handwritten, my lord. All their answer sheet. So that means that
No, does it tally with the marks given
yes,
in the?
my lord, it is tally with the marks, with the overall marks.
Hmm.
So the overall marks obtained by the candidates, which the department has made in a computer format, it is tally with the handwritten format, my lord.
Where's the allegation? Your allegation that it does not tally, or it is only handwritten. It's not hand. It's by way of computer printed.
Yes, my lord, in page number 86. Yes. That is RTI reply. That English translation is in the next page, page number 87.
So there might be some sort of, like.
Yes, my lord. Yes, in para number 16, my lord. Page number 37.
Xerox copy of the original table mark.
Yes. It is applied through the RTI.
How many tables were there?
Pardon, my lord.
How many tables?
Six tables, my lord.
Is it available in the records regarding the marks given by each table?
Yes, my lord, it's available.
Can I have a look? Is it open? Give me one table. Where is that table thing mentioned in your writ petition? 6 tables.
Yes, it is with respect to practical.
No,
test
where is
table.
that? Where is that given in your writ petition? Show me.
In para number 16, my lord.
No, not paragraph. The scheme of the test. I just want to see.
That is not specifically mentioned in my writ petition.
Then how do you say that there are 6 tables? From where you're saying that there
From
are 6
the
tables?
page number 74.
74.
Yes. Table, number of table is indicated.
Where is that?
In the 4th column, my lord. That is number of table.
Table 5, 4, 2, 6. This is for the post of
Havildar to sub-inspector promotion.
Havildar to sub-inspector.
Yes, my lord.
You come to page 50, annexure 1. This is a notification.
Yes, my lord.
DPC is constituted by the following officers. Chairman is there, then the representatives are there.
Yes, my lord.
Then the next page, page 51, chairman is there, then members. There are 6 of them. So all these 6 persons have their own separate tables, or what?
Yes, my lord.
How do you say 6 tables?
There are 6 members in the practical test board. Then there are, it means that there is 6 tables.
Then page 55 is the practical test board. Again 6. So these are all the same persons,
Yes, my lord.
isn't it?
Yes, my lord.
Then page 56, we have table 1 to table 6 now. This is how it's done, table 1 to table 6. Then on different dates, you have the kind of test to be conducted. Personal turnout, medical examination, then proficiency in drill, command and control, weapons, practical, field craft, and map reading, weapons in writing, in written. Ms. Vanishami,
Yes, my lord.
see, these are also printed.
That
You
is
said-
the official record of marks obtained by all the candidates in outdoor subjects, my lord. And there is another package that is field craft and map reading, and this is a written. This is their answer sheet. So it has been packaged in different package, my lord.
No, the marks, how are they given? They're not, it's not given by hand,
This is given by hand, my lord.
each individual.
Yes, my lord. It's individual. Their answer sheet.
Have you checked up? Does it tally with this? What is this which you have given me? This is proficiency in drill, command. This comprises of the entire thing.
That is the outdoor subject, my lord.
Outdoor.
Yes, my lord.
And what about the indoor test?
This is the medical report of each
Okay.
candidate.
And
So
then?
they have made, and this is weapon theory. Weapon theory.
Weapon theory.
Yes, ma'am.
Written exam.
Yes, ma'am. Written exam.
And how is it given? Like it's in writing.
It's all in writing.
Marks tabulation is given in, it's in writing.
Yes, it's done. It's written like that.
See, the thing is that can you prepare a chart? Because going through all the papers will be difficult.
Yes, my lord.
That envelope one is regarding
Medical report.
medical, and the other one
weapon theory,
Weapon theory, medical, then
and marks obtained in outdoor subject.
outdoor subject.
Yes.
And,
These three are there, my lord.
okay.
And this is the overall result. And this is the attendance sheet.
Overall result means it includes all those.
Yes, my lord. It
Okay.
includes it and everything.
Give me that overall. Is it comparable to Annexure 12 in the writ petition? What I wanted to know was that these overall marks given here, and the one which is tabulated in writing, are they the same or not? This is what we wanted to know. Like this is Havildar Rual Khub Thanga, table number 1. Weapons theory. Where did you take out this from? Weapons theory, isn't it? Give it back. Put it back inside. And this also, this was sealed, isn't it?
Yes.
It was a seal envelope.
Yes.
Please reseal it again. You have a sellotape there? Seal it. And give back this one also. So, Mr. Pianfella, you tell me what is your grievance? Please recapitulate.
Yes, my lord. While we are applying our marks through the RTI,
You'll get your marks. You want marks of others. The others who do not object, they'll give you. But for those who object, they're not giving you. So what is wrong in that?
Yes, my lord. My submission is that while we are applying for our original table marks, it is not. It is stated that it is not submitted to the PHQ. Then they have also stated in their affidavit in opposition, para number 6, that with regard to the statement made in para number 16 of the writ petition, I say that practical test both submitted the computer type marks obtained by candidates to the Departmental Promotion Committee, wherein the Departmental Promotion Committee compile it and prepare the overall result and then submit the recommendation of selected list for approval to the DGP. As such, unfairness, discrimination, and obscurity do not arise. That is.
You are reading from which paragraph?
Affidavit in opposition, para number 6.
So what is wrong in this?
Well, they are saying that the state respondent are saying that original table mark was not submitted to the PHQ, so that is not furnished to us. Well, it is not furnished to us.
Is it necessary to furnish to the PHQ? The table, 6 tables are there. They will make their assessment, give their marks, and those which are written papers, answer sheet I've seen just now.
Yes,
this particular gentleman got 8 marks. And as per the tabulation, it's exactly 8 marks. This is not just one instance. So, the test board will prepare the tabulation.
Yes, my lord.
On the basis of the papers which they have seen. Papers contains the marks evaluation by paper correction by way of writing. The total marks given, it is given in the chart. And that chart itself, tabulation goes to the PHQ. And in the basis of the chart given to the PHQ, they have selected the candidates, which in turn was sent to the authority concerned for approval for final decision. So where is the question of there being, giving the wrong entries?
That practical test subjects regarding command and control, drill, fieldcraft, map reading, this shall be that the marks shall be given in handwritten, and that handwritten was not furnished to us.
Where's that command control drill and all that? From where you see?
From page number 74, Annexure 12. There is a practical subjects from column number 13 to
13, yes, 13, 14, 15.
Yes, but in weapon there is a practical marks, theory marks, 10 marks. But the other columns shall be are practical subjects.
This is a chart prepared, overall result.
Yes.
What is the basis of preparation of this chart, Ms. Vanesiami?
Yes, my lord, this chart is made on the basis of the report, which is
Turnout, drill, Command and control.
Yeah, this is outdoor subject, my lord. These all are outdoor subject.
Outdoor subject.
Yes, my lord.
No, but who gives the marks? The table, the person who is in charge of the table concerned. But is it not handwritten initial stage?
No, my lord.
Straight away, how can it be computerized? What is the process? Altogether, there were 213 candidates. How many candidates are there? No, more than that. 215.
215, my lord.
215 candidates appeared. So, question is, how do you tabulate the turnout marks, the drill?
Command and control, my lord.
Command and control.
Fieldcraft, map reading. Then in weapon also there is a theory and practical. Practical, you carried 10 marks.
See, the written test, you've shown me the papers. Answer script is there. So, it's corrected by hand.
Yes.
Marks given by hand.
Yes, my lord.
That is okay. But in respect of turnout, drill, command and control, how marks are given? Who gives the marks? Should it not be given by hand in the first entry?
I have no idea.
Roll number 1 comes, okay, this much marks. Number 2 comes, this much marks. Later on, for the sake of convenience, you prepare a chart, no problem. But the original tabulation, how was it done? Because these are all different tables, 1 to 6, 1, 2, 3, 4, 5, 6. So, on different dates. What have you stated in paragraph 16?
Yeah, may I read out, my lord? That P. Nuneng, a resident of Chiangabeng, Aizol, had submitted an application dated 21/3/2024 under the RTI Act 2005 for obtaining Xerox copy of original marks in selection of for the promotion of Havildar to the rank of SIAB held during 29/1/2024 to 5/2/2024. The SPIO had furnished RTI reply on 29/4/2024 and unexpectedly informed her that there was no Xerox copy of table marks to be furnished to her, as the same had not been submitted to the PHQ by the practical test board. This reply against the RPI application had clearly revealed that the selection was carried out with unfairness and partiality. It had also indicated that transparency was not maintained in respect of the practical test. Every participant should have a fair chance to thrive based on their merit, not on discriminatory factors. A selection process presided over by the internal motive of the unfairness, discrimination, and obscurity. The same suffers from several errors and is unsustainable on the settled principle of law. That is my submission.
No, so the thing is that the SPIO furnished the reply.
Yes.
And informed that there was no Xerox copy of the original table mark.
Yes.
Xerox copy of the original table mark. Why do you require that?
It is applied with an intention that original table mark shall be
table mark is
made
there.
a Xerox
Original table mark is
copy.
there.
It's here, my lord. It's there, my lord.
You have shown me, na, that original table mark.
Yes.
That's the one.
And this is the mark scoring sheet.
It's
regarding-
printed. It's in the
Yes.
printed form, isn't it?
Yes, my lord. It's printed form and it's they made a total. Here.
See, two numbers have been added together. Why do you require to add two marks together? 4.5 plus 4. Okay, this is FC and map reading.
Yes, my
FC means
Fieldcraft, my lord.
fieldcraft.
And this is proficiency in drill.
These are all entered by computer.
Yes, these are all entered
By
in
computer.
the overall.
No, question again is it not initially to be done by hand? This much mark.
I have no idea about that. That is the record. And my lord, if I'm not mistaken, there is no rules that there have to be only in handwritten. And even in the standing order, my lord, it is not mentioning that the marks obtained by the candidate should be in a handwritten.
No, the original. The first tabulation, like you have the answer sheet which you just show me.
Yes, ma'am.
Answer sheet. The person has written by hand. Evaluation has been done by hand. And later on the marks given in that answer sheet is transferred to the overall sheet, overall assessment. So similar process in respect of fieldcraft and map reading. Like the first serial number is 4.5, then it says 4.5 plus 4. Where is that 4.5? Who has given that 4.5? From where has it been entered? This is what I'm asking. Each table has given their own marks, isn't it?
Yes, my lord.
So where is that marks given by them before it is transferred to this chart? That is what I was asking you. Not that, I'm not saying that it should always be written in hand. It should be printed for convenience, but the source of the print, that process has not been explained by you anywhere, is it, in your counter affidavit?
No, my lord.
How you have
There is no
evaluated?
explanation regarding to that.
What about this video coverage?
Yes, the practical test was covered through video camera. Then that was recorded, all their performance were recorded. Then the same was applied through RTI, and the same was furnished to us also.
Okay.
Then we have made a request to review that video coverage also to the DGP, but nothing has done on our representation.
What is covered by that video? Firing and all that?
Firing and all these practical tests.
Okay.
Individually, all worker, there is a cover.
Right, we'll come back in the afternoon.
May I seek a lordship indulgence? My lord, I'm so sorry to interrupt, but can lordship item number 16 of the hearing column? Item 16.
Yes.
Yes, my lord, can it be fixed after a week?
Why?
Because my lord, today Mr. Sharaf cannot appear.
Who?
Mr. Sharaf for the respondent number 1.
Saurabh.
Yes, my lord. I'm for the appellant. I'm for Mr. Pakoma.
Okay. Let's pray for, on behalf of Mr. Saurabh Pradhan, learned counsel for respondent number 1. List the matter again after a week. Item 60.
Obliged.
No, you can mention the process and you can just say that where it is available. The evaluation has been done in such a manner, step by step, how it has gone. And you can just say that these are available in the records. So that when the court sees that, I can cross-check the contents as well as what you've mentioned in the affidavit.
No matter what I mean to say is that when I mention about the marks obtained,
You should not mention the marks, not required. You don't disclose the marks.
okay,
You just have to say that this is the procedure followed by you, and these are the documents which is available, and which is ready for perusal of the court whenever is required. Then that way, because there are certain steps, isn't it? Like you have 6 tables and you have the various kind of, what do you call, the outdoor and the other tests that you have. You just have to explain how those tests have been done, who has done it, and how the tabulation has been done. That much only. And whether the actual marks match or not, that we'll see for ourselves. Court will see for itself. Otherwise, to go through the entire box will be difficult for me. I'll give you some time, no problem. How much time should you require to prepare the affidavit?
my lord, at least 4 weeks.
4 weeks.
Yes, my lord.
Mr. Pianfella, will adjourn for 4 weeks then?
My lord, it 2 weeks.
I don't think you should require 4 weeks, otherwise, Ms. Vanasirni. Make it 3 weeks, okay? And if you cannot prepare it by then, we'll consider giving you the time.
Yes, my lord.
Please write down, parties are represented by the respective councils. Stop. Ms. Vanasirni, learned government advocate, has produced the relevant records as directed by this court. Stop. However, since the records are bulky, the learned government advocate shall file an additional affidavit explaining the manner in which the selection process has been conducted and the manner in which the tabulation has been made without disclosing the actual marks obtained by each of the candidates. Stop. The said process is required to enable the court to peruse the records and at the same time compare the tabulation so made. Stop. In order to file the additional affidavit as directed, the learned government advocate is given 3 weeks' time. List the matter again after 3 weeks.
Obliged, my lord.
There's one part of your record which is still here. Give her like this.
Item 12 and 13 hearing.